Okay, it's Tuesday, 19th July, 2016 at 5:26 p.m. I ate my salad dinner, so I'm pleased with that. I added an extra ingredient, which was just a normal potato, half of a normal potato. So I have the sweet potato is like really big, so I break it up into three slices, and three sections. And I have one section every day, and half a normal potato, and so mm, nice. Yeah, it's good to eat those veggies. Had a peach, no, not a peach, a pear, but I don't know if I should have that pear tomorrow. Maybe I'll maybe half a pear or something. I don't know. I don't want to eat too many sugary stuff. Anyway, so yeah, I got like a concession card, like a pensioner card from Centrelink, and I'm like, why the hell did they give me a pensioner card? My mom's saying like using this card, like all train fees are like only $2.50. So it's like, why did I get that? I didn't get my disability thing, but maybe my circumstances have changed or something. I don't know. So that was a bit strange. Like, why do I have a pensioner's card? It doesn't make sense. But I'm not gonna use it. Because I'm not sure if I should have it. But anyway, so let's do this. Wait a minute. Oh, window capture. Yes, that's the one. I'm looking for the window. Come on. Come on. I want the window. Yeah. Yeah, good. Oh no. It's the. Let me just close that. Yeah. I will have to click this. Bring it down here. Bring it down here. Yeah, so I might, it's possible. Yeah, so I might get my statutory declaration. Hopefully, I mean, for my character reference. Fingers crossed for that. Why is this like that? Oh, okay. Yeah, but I haven't heard from my psychiatrist, and that's a bit concerning. That's a bit concerning. Okay, I actually recorded like one of the previous videos at 60 frames per second, and when I tried to re-encode it to make the file smaller, the re-encoding was totally messed up. So I'm back to 30 frames per second, and hopefully maybe I can re-encode this. Alright, let's see, where is that file? Yeah, there's a lot more CPU power. See, it's not as slow. Oh yeah, I'm currently seeing season 7 of the Mad Men TV show. Yeah, I kind of like that show. So season 7, I just bought it a couple of days ago. So that's the last season. I just want to finish it. Okay, number 15, Lien over, how do you say that? Lien over essential documents. So Lien is like a qualified proprietary interest. 15.1, notwithstanding Rule 14, when a solicitor claims to exercise a lien for, there you go, a lien for unpaid legal costs over client documents which are essential to the client's defense or prosecution of current proceedings. Oh, that's what they call it, essential documents, right? 15.1.1. If another solicitor is acting for the client, the first solicitor must surrender the documents to the second solicitor. 1. If the second solicitor undertakes to hold the documents subject to the lien and with reasonable security for the unpaid costs, or 2. If the first solicitor agrees to the second solicitor agreeing to pay or entering into an agreement with the client to procure payment of the first solicitor's costs upon completion of the relevant proceedings, or 15.1.2, alternatively, the solicitor, upon receiving reasonable security for the unpaid costs, must deliver the documents to the client. So, okay, so that's a way of, let's say you're holding some essential documents which are, to the client's defense or prosecution, because they haven't paid any legal costs up to that point. So these are the circumstances in which this you must see. They use the word "must" surrender here. So 15.1.1, you must surrender the documents if there is another solicitor acting for the client, and that solicitor undertakes. It's an undertaking to hold the documents subject to the lien, or the word "or," if the second solicitor agrees to pay or enter into an agreement. Right. Or alternatively, the solicitor upon receiving, so the client can, instead of paying the legal fees, they may, let's say, give a mortgage over their house or something, reasonable security for the unpaid costs, or maybe a mortgage over the car, who knows. You must deliver. You see the word they use, the word must, because I think they're just trying to ensure that clients people get an opportunity to defend their legal issues, and the issue of costs. They're trying to make sure costs aren't an obstacle to clients having their legal matters heard in court, right? Let's say you just couldn't pay the fees on time or whatever, and if the solicitor is holding some of your essential documents on this lion thing, this rule provides a way for the client to obtain those documents. So reasonable security, or if there's another solicitor acting for the client, okay. 16, because they're just saying that, don't let this cost thing be a barrier to having your day in court, especially if it's very important, right? 16, charging for document storage. 16.1, a solicitor must not charge 16.1.1 for the storage of documents, files, or other property on behalf of clients or former clients of the solicitor or law practice, or predecessors in practice, or 16.1.2 for retrieval from storage of those documents, files, or other property, unless the client or former client has agreed in writing to such charge being made. So I guess if you're going to charge for document storage or retrieval, you need to get a written agreement from the client or former client. Really? Okay. I guess that's a way of giving clients an opportunity to know that there will be costs involved in storing documents, files, or other property. If you're intending to charge for that storage or retrieval from storage, you have to let the client know. Again, just giving clients a heads up, just taking care of clients' interests, advocacy and litigation. 17, independence, avoidance of personal bias. So this is for advocacy. Obviously, this is the court proceedings. 17, independence, avoidance of personal bias. 17.1, a solicitor representing a client in a matter that is before the court must not act as the mere mouthpiece of the client or of the instructing solicitor, if any, and must exercise the forensic judgments called for during the case independently after the appropriate consideration of the client's and the instructing solicitor's instructions where applicable. So yeah, so that's saying that if you're going to represent a client, you have to seriously consider the client's case and not just show up in court and say, all right, I'll just say this or say that. That sounds so bad, but yeah, you have a duty to, if you're going to represent someone, you have to seriously look at the facts, look at the legal issues, make your own independent judgment. Don't be a mouthpiece for the client or of the instructing solicitor. The instructing solicitor can be like the person who's actually employed by the client, and that solicitor may hire you to represent the client in court, maybe because you're better at litigation. Usually they call barristers to do the litigation, but maybe barristers are more expensive. It's barristers, they argue in court. That's what they do. And an instructing solicitor tells the barrister what the client's case is and stuff. Okay, all right, another email. Change.org thing. 17.2. A solicitor will not have breached the solicitor's duty to the client and will not have failed to give appropriate consideration to the client's or the instructing solicitor's instructions simply by choosing, contrary to those instructions, to exercise the forensic judgments called for during the case so as to 17.2.1 confine any hearing to those issues which the solicitor believes to be the real issues. 17.2.2 present the client's case as quickly and simply as may be consistent with its robust advancement. Or 17.2.3 inform the court of any persuasive authority against the client's case. So this is like these see 17.2.1 to 17.2.3, if you look at them, they seem to be detrimental to the client, right? So if you are acting for the client and let's say the client is talking about these are all my problems, and then but you exercise your forensic judgment and say actually what we should be talking about are only issues 1 and 2. Let's say the client thinks there are 5 issues, or the instructing solicitor thinks there are 5 issues, but you exercising your forensic judgment say no, actually there are only 2 issues. The client may get the impression that, oh my God, well, that's not really good for me. I need to raise more issues. But what you're doing is you're actually helping the court. You're not wasting the court's time, right? If you made a judgment that there were only 2 legitimate issues instead of 5, you have to act upon your own personal judgment. And you shouldn't listen to the client or the instructing solicitor, because they might have, especially the client, because they might think, oh, there are much more issues. They might not understand what's actually at stake here. They might not understand like what matters. So even though it's the client, it seems detrimental to the client. What you're trying to do here is trying to make sure the court's time and resources are not wasted, and that you actually have there is a law in the Civil Procedure Act which requires legal practitioners to conduct cases efficiently and not waste time. There's actually a law requiring you to do that. Even if you look at 17.2.2, present the client's case as quickly and simply as may be consistent with its robust advancement. So yeah, you're not going to linger on and talk about all of these side issues. You're just going to try and attack the main points head on, keep it focused, inform the court of any persuasive authority against the client's case. So that 17.2.3 might certainly seem like, oh, detrimental to the client, but if you know of an authority. Authority means basically like a decision by a judge in a case. You should let the judge know. That's an interesting point. 17.2.3. Inform the court of any persuasive authority against the client's case, because what you're trying to do is you're trying to actually find what the legal issues are, what is the law that's applicable to those issues, what the facts are, and apply the law to the facts. So you shouldn't try and mislead the court. So you see how here your duty to the court is the to conduct proceedings fairly, is sort of like it's making itself shown, like in these in 17.2. So that's why you have to be like an independent. You have to make independence, avoidance of personal bias. 17.3. A solicitor must not make submissions or express views to a court on any material evidence or issue in the case in terms which convey or appear to convey the solicitor's personal opinion on the merits of that evidence or issue. So that's a very interesting rule. In terms which convey or appear to convey the solicitor's personal opinion on the merits of that evidence or issue. So if you are representing a client in a court, you shouldn't use tone or the wording that you use, the language that you use to present the legal issues and the evidence used to support them. You shouldn't present them in a way that indicates to the judge your confidence or lack of confidence in the merits of that issue or evidence. So it's like, again, try not to be biased. Try not to even appear to be biased. See, convey or appear to convey. Alright, that's a very interesting rule. 17.4. A solicitor must not become the surety for the client's bail. What is a surety? Is that like a what do you call it? A person who takes responsibility for another's performance of an undertaking, for example, their appearing in court or paying a debt. So like you're like you're gonna take an undertake. You're gonna say, all right, yeah, Google Google it. All right. Alright, so you cannot be the person who's going to be responsible for the client's bail, or maybe you can't pay the client's bail, I think. Anyway, good to get some clarification on that. Alright. 18. Formality before the court. 18.1. A solicitor must not, in the presence of any of the parties or solicitors, deal with a court on terms of informal personal familiarity which may reasonably give the appearance that the solicitor has special favor with the court. Alright, so this is like appearances, like uh, there's that phrase, not only must justice be done, but justice must also be seen to be done, because because in order to maintain, in order to for the public to have confidence in the impartiality of the judicial system, you know what I mean? So this formality before the court is like, if you're going to go to court, and if, let's say, if you know the judge or whatever, you've appeared many times before, you must still act with formality, because otherwise the public will think, oh, wait a minute, these two people know each other and they're like friendly with each other. This doesn't seem like a, it creates a bad impression of bias. So the way justice is seen is just as important as whether justice is done. You know, the perception of that justice is actually being done is important, because that perception will impact on the public's confidence in the impartiality of the judicial system. So keep things formal. All right, 19, frankness in court. 19.1, a solicitor must not deceive or knowingly or recklessly mislead the court. So, yeah, that's a pretty strong, direct statement. Don't lie, or don't be reckless. Again, be diligent, competent. Yeah, don't mislead the court. Don't lie to the court. Be honest. 19.2, a solicitor must take all reasonable steps to correct any misleading statement made by the solicitor to a court as soon as possible after the solicitor becomes aware that the statement was misleading. So if you make a statement that is misleading, let's say you made a statement, right? And let's say a few days later you discover, let's say it was through human error, let's say someone working for you did not do the proper research and gave you a half truth, not accurate information, and you made that statement, and later on you find, how do I have to explain it? I mean, that's pretty. So this is just, so if you make a mistake, it's not the end of the world. Just correct it. Be open and honest. Again, that's that frankness thing. Don't try to cover up mistakes. If you make a mistake, don't try and cover it up. Own the mistake. Let the court know as soon as possible. Okay, so you may be yelled at or whatever, but it's better to be yelled at rather than trying to cover up a mistake, because that is ground for being struck off the roll. So if you make a mistake, own the mistake and correct it as quickly as you can. 19.3, a solicitor will not have made a misleading statement to a court simply by failing to correct an error in a statement made to the court by the opponent or any other person. So I think that's an interesting statement, because it's like, because your role in the court is to advocate your client's case. It's a adversarial system, right? So if the opponent fails to, if the opponent makes a misleading statement, not a misleading statement. If the opponent makes an error in a statement, and let's say the opponent makes a statement which you know to contain an error, but you realize that statement might be favorable to your client. you don't have an obligation to correct the error made by the opponent or any other person, even if uh, even if you know that there's an error and they don't know, and even if you know that that error, that erroneous statement is advantageous to your client. So this is the one way in which, let's say, you can advocate for a guilty client. Let's say your client was guilty. Let's say you knew they were guilty. You cannot say, my client is not guilty. This statement. What you have to do is you have to make the opponent prove their case beyond a reasonable doubt. And so this rule is a sort of it's sort of open. It's sort of it allows you to advocate for guilty clients. So it allows you to, basically, participate. You're participating in an adversarial process, and the game is set up that you present your best case, the other party presents their best case, and who has the best evidence to support their arguments wins. So can you understand like how this 19.3 is written in a way that failing to correct an error in a statement made to the court by the opponent or any other person is not synonymous to making a misleading statement. So you don't have to correct the error. You can, but you don't have to. Anyway, it would be interesting to actually get more clarification on this rule. I think there's a way this rule can be. I think there might be some commentary on how to use this. Because I was reading in the College of Law about advocating for guilty clients. How do you advocate for guilty clients? Because you cannot lie to the court, you know. You cannot lie to the court, but at the same time you don't have to correct an error in a statement made by your opponent. Do you know how that sort of those two obligations are? It's sort of like a way, it's opening the door for, anyway. It's an interesting rule. 19.4, a solicitor seeking any interlocutory relief in an ex parte application must disclose to the court all factual or legal matters which 19.4.1 are within the solicitor's knowledge, 19.4.2 are not protected by legal professional privilege, and 19.4.3 the solicitor has reasonable grounds to believe would support an argument against granting the relief or limiting its terms adversely to the client. God, how long is it? Oh my God. Oh, here it is, delinquent or guilty clients. There's a special rule for that, delinquent or guilty clients. Yeah, that would be... if my understanding of Rule 19.3 is wrong, I will seek to get clarification on that. An interlocutory relief is like when a case has already commenced, you can make submissions to have certain things done. This is after a case has already been commenced. An ex parte application means like when you're making the application, the other party is not there. You're making the application in the absence of the other party. So basically, in that case, circumstance, you have to disclose all factual or legal matters, which are, okay. He's going into more detail on that. How long is this? I'm getting tired. Okay, I'm just getting a bit tired. I'll just do my browser interlocutory. Yeah, of a decree or judgment given provisionally during the course of a legal action. Example is an interlocutory injunction. Ex parte. With respect to or in the interest of one side only or of an interested outside party. See, this legal dictionary says, let's go to that. An ex parte judicial proceeding is conducted for the benefit of only one party. Ex parte may also describe contact with a person represented by an attorney outside the presence of the attorney. The term ex parte is used in a case name to signify that the suit was brought by the person whose name follows the term. Okay. So it's sort of like India, one party alone, like one party alone, done by for on the application. So it's like only for one party. Ex parte application. So I will, I will continue with 19.5. Yeah, alright, I'll continue with that tomorrow, hopefully.